Hello, my name is Lori Schaefer, and in this video, we will be discussing mediation. Mediation is a voluntary service. It is available for disputes pertaining to preschool and school-aged children. It is important to know both the parent and the LEA must be willing to participate where the mediation does not take place. If either party chooses not to participate in the mediation process, no one, including ODR, PDE, or the opposing side, can force the other side to participate. Sometimes one of the parties may believe a fact finder is needed to break the impasse and not a mediator. In that case, they will likely decline to agree to participate in mediation. Regardless of the reasons, ODR respects the decision-making of both parties to participate or not participate in the mediation, while of course considering the high success rate of this conflict resolution service. The spirit of mediation is one of collaboration and respect. For mediation to be successful, it is important both parties come ready and willing to discuss the issues, bringing them to mediation. If not, mediation may not be successful. If mediation is successful and an agreement is reached, a written agreement is binding in a court of law. It is also important to know that using mediation does not take away any rights to due process for either the parent or the LEA. Due process and mediation can be requested at the same time. Since mediation takes less time to schedule than a due process, many times when parties go to mediation and reach an agreement, the due process request is withdrawn. Mediation is considered less stressful, less time-consuming, and less expensive than going to a due process hearing. Once both parties have agreed to participate in the mediation process, ODR handles the scheduling details. This includes coordinating the date and time, obtaining the list of participants for each side, and assigning a mediator to the case. For special education mediations, there is no cost to either side for the mediation. In gifted education mediations, the LEA is responsible for the cost of the mediator. You may be wondering who the ODR mediators are. The Individuals with Disabilities Education Act requires that mediators be impartial, trained in effective mediation techniques, and knowledgeable in special education law and regulations. The ODR mediators are independent contractors. They come from a diverse field of experience and expertise, such as attorneys, private mediators, meaning they also mediate for other organizations and groups, consultants, former educators, therapists, and college and university professors. You can view mediators' biographical information on the ODR website. Who are the participants that will attend the mediation? In Pennsylvania, attorneys do not participate in the mediation process. Mediation is an opportunity for the parent and the school to sit down with one another in an informal setting in the presence of a highly trained mediator to discuss issues and brainstorm creative solutions through facilitated discussion. The parents are welcome to bring up to 3 participants to the mediation. This could be a family member or a friend, a therapist, an advocate, or another person with knowledge of the situation. The LEA will also select their 3 participants, as long as one of their participants has the authority to implement an agreement if one is reached. The LEA will provide ODR with a signed form stating this participant has the authority to make decisions for the LEA. For mediations involving children in the infant-toddler group, this would be children birth to 3 years of age, there are a few differences in the process. For these mediations, the process is not voluntary. When a parent requests mediation, the infant-toddler program must participate. The mediation for this age group must be scheduled and held within 10 days of receiving the request. If the mediation is successful, the Office of Child Development and Early Learning, OCDEL, receives a copy of the signed agreement for follow-up. What can you expect at the mediation? Each side will have the opportunity to present an opening statement. This is where the parent and the school each have uninterrupted time to explain their viewpoints on the disagreement. After both have given their opening remarks and the mediator has asked the clarifying questions needed to understand the situation, the joint session will begin. This is where the mediator facilitates dialogue between the parties, discussing the disagreement and possible ways to resolve it. At some point, the mediator may ask for a private meeting with either the parent, the school, or both. This is called a caucus. and the mediator may suggest a caucus if he or she thinks it might be valuable. The caucus is used to gather further understanding of any roadblocks preventing an agreement. The parent and school may also want to request a private caucus during the mediation. After the caucus or caucuses, the joint session resumes. The goal of the mediation session is to reach an agreement, and the mediator will work with both parties to help reach this goal. If an agreement is reached, the mediator will put it in writing and have it signed by the parties, also giving both parties a copy to take with them.